David, you're on News 96.5. Go ahead.
Hey, I got a question. My wife recently became, I guess, terminally ill, maybe. And we have a $50,000 life insurance policy on her, and I'm the beneficiary. And then, of course, she is listed on my house as, on the deed to the house, but she's not listed on the mortgage.
Okay.
And then the only other thing that she would have in her name would be her vehicle.
Got it.
So what would I need to do as far as if she passes away? Am I going to have to go to court and all that stuff? I mean, she has one child.
So David, I understand. So David, first of all, I'm very sorry about your wife. So first of all, life insurance does not go through probate. If she passes away, all you have to do is show the life insurance company her death certificate, and they'll write you a check. Number two, as far as a deed to the house, as long as the two of you are identified as husband and wife, meaning it's got both your names, comma, his wife or husband and wife, her interest in the home is not going through probate. She passes away. The only thing you have to do is to record her death certificate in the public records, and her half of the home will automatically belong to you. Number three, vehicles do not go through probate. If she's got a will that says, when I die, I leave everything to David, then you pass away. All you have to do is go down to the tag and title office, and they'll retitle the car in your name. Now, with that said, as far as that is concerned, David, it might be nice while she's alive to pull out the title, if you've got it, and have her sign it over to you. David, does that answer your questions?
Yeah, pretty much. Only one other question. Would it be easier while she is still alive to have her maybe sign a quick claim deed on the house?
No.
Or would that even be necessary?
As long as both of your names are on a deed and that identifies you as husband and wife, that would not be necessary.
Okay. Yep. That pretty much answers my question.
All right, David, thank you for calling. What do you think, Chrissy?
I absolutely, of course, agree with everything you said, but in addition, I think what David brings up a good point, and again, David, sorry about your wife, but about while she is still alive, about a power of attorney.
Oh, yeah.
So I just wanted to add that because I think that that's something where, again, Tom, you covered everything about if she passed away, but if for some reason, and I know David didn't necessarily get into it, if she has a 401k, she has a retirement account in her own name, that David is the beneficiary, but what about if she becomes incompetent while she's alive? He absolutely needs to have a power of attorney. And as we know, that's one thing where even married couples don't realize that power of attorney documents are so important because it's about if your spouse is alive but incompetent, and that is what's going to allow you to be able to help and transact business on anything that happens to be in their name only.
Yeah. Well, you triggered me that also she would want to have a living will.
Oh, of course.
Yeah, living will where she asks that she not be kept alive by machines. So,
To
David,
me, those three.
Yeah, so the issues you called me about, you're all clear to go, but we think that she should have powers of attorney where she appoints you to make health care decisions for her, take care of business for her if she's not able to, and a living will where she's asking that she not be kept alive by machines. David, if you need some help with those things, we'd be more than happy to assist you. All right, folks, my name is Tom Olson. The name of the show is Olson Law. You're listening to News 96.5.